From KAMR Local 4 News, your local election headquarters, this is Politics Today.
A candidate for Amarillo City Council pleaded guilty to theft and ultimately has no felony conviction. Find out why he says there is a difference between pleading guilty and being guilty. And we're continuing our coverage over the proposed Ten Commandments monument here in Amarillo. Hear what the attorney who has agreed to represent the city has to say about the likelihood of a legal challenge. The municipal election is coming up in May, and 15 candidates filed to be on the ballot for Amarillo City Council. KMR Local 4 News has discovered one candidate in place 4. Leif Curtis was placed on deferred adjudication after he pleaded guilty to theft of tens of thousands of dollars from his employer, a church. This was in 2018. Records show that Curtis successfully completed deferred adjudication. The case was dismissed, and he has not been convicted of a felony. Politics Today's Princess Bryant investigates.
Leif Curtis is a candidate for Amarillo City Council Place 4. According to this Potter County plea memorandum, Curtis in 2018 entered a guilty plea in Potter County's 251st District Court on charges that he had stolen money from First Christian Church in Amarillo, where he was the Director of Administration and Finance, a Securities and Exchange Commission report says.
It was an unfortunate case where I trusted somebody at their word. I didn't get contracts signed appropriately. I take full responsibility and accountability for my part in that. And I've learned from that. If anything, I can be a testament to God's redemption, giving second chances and whatnot.
This is a third-degree felony for theft of property of an amount of $30,000 or more, but less than $150,000. Curtis had to pay more than $37,000 in restitution to the church and serve a probationary period to successfully complete deferred adjudication, court records state.
I was not ordered restitution, no. They're like, hey, like you weren't supposed to have that. It was, okay, here, have it back. I'll pay it back, 100%. Like I said, I didn't cross T's, I didn't dot I's. That's why there was no conviction. That's why charges were ultimately dismissed.
The complaint filed by 47th Assistant District Attorney in 2018 says Curtis stole the money from First Christian Church from May 2015 through February 2017. In the complaint, the pastor of that church at the time is listed as the owner of the property and the victim. The church located at 3001 Woodland Avenue has services Sunday mornings at 10. Curtis served the church for a little more than 2 years, according to the SEC report.
I'm holding myself accountable to that. Whether it's against a church or whether it's against just an individual taxpayer, it shouldn't happen regardless, which is why I've made the changes, which is to make sure that something like this doesn't happen to me again, and it won't happen to them either.
We reached out to the church for comment. They declined. Curtis entered his guilty plea on June 28, 2018.
I think anybody who has anything in the legal world knows that there's a big difference in pleading guilty versus being guilty. Now, again, I've never taken granted my accountability in the aspect of it, but there was no malice in what I did. It was not something that I did to try and gain anything.
In accepting his guilty plea on July 11, 2018, 251st District Judge Anna Estevez put Curtis on deferred adjudication for 2 years and ordered him to pay a $625 fine and the full $37,741.19 in restitution. She also placed Curtis on community supervision. Some of the conditions from that probation included no contact with the victim, electronic monitoring, and no alcohol.
Charges were ultimately dismissed. Even after being placed on deferred, being placed on probation, I was even let off early, which rarely happens in any cases really in Potter County.
I talked with Amarillo attorney Kevin Eastern, who was not involved in this case, but agreed to review these documents.
In Texas, if you're charged with a criminal offense and you receive what's called deferred adjudication, that is, the court does not find you guilty and put you on a specific type of probation. And once you complete all the terms of the probation, the reward for doing that is you don't have a conviction.
At the time of his plea, Curtis also was working at an Amarillo branch of the investment firm Edward Jones as a financial advisor, a Securities and Exchange Commission report stated. About 3 weeks after Estevez's ruling on July 30th, he was fired. Quote, Mr. Curtis failed to timely report a charge and guilty plea for felony theft, end quote, the SEC report says.
The reason for the termination, again, was because of the matter of the crime.
Okay.
My lawyer let them know as soon as they were told, or as soon as we knew. So So yeah, it was just because of the U5. But like I said, I'm reinstated. I can go back and work for any financial services company that I want to work for now.
In March of 2020, the judge terminated his deferred adjudication a few months early, court records show. It says, quote, "The ends of justice have been served," end quote.
So absolutely, people deserve a second chance.
And another layer to that, do you think people in a position of power deserve that same grace as well?
Yeah. We're all redeemed, right?
Curtis is one of 3 candidates on the May 3rd ballot for Amarillo City Council Place 4, along with incumbent Les Simpson and Sylvia Stevens. KMR Local 4 News found no criminal records for Curtis's opponents or any other candidate for Amarillo Mayor or City Council. We have documents related to Curtis's case at MountHighPlains.com. There, we also have our complete interview with Curtis, where he talks more about this case and why he wants to be your City Council member. Coming up, we have a follow-up to our coverage from last week over the proposed 10 Commandments monument here in Amarillo. Still ahead, we'll hear from First Liberty attorney who has agreed to represent the city if the monument is challenged in court. We're following up now on a story from last week about the 10 Commandments monument proposed by Amarillo City Council. Since the public meeting regarding the monument in November, the city has entered into an agreement with First Liberty Institute attorney Hiram Sasser will be the one representing the city if there is a legal challenge for this monument. We reached out and spoke with Politics Today's Devin Singleton last week. Here's what he had to say.
First off, if you want to just kind of go through kind of the agreement you and the Amarillo City Council are kind of working on just for your representation on this monument.
Oh, sure. Just like we represent the state of Arkansas and we've represented other governmental entities, we're representing the city of Amarillo to assist them in making sure that they're complying with all the Supreme Court precedents that frankly, our firm helped establish, and based on the wins that we've had at the U.S. Supreme Court, to make sure that their 10 Commandments monument complies with those precedents of cases that we won at the Supreme Court over the past few years.
And so go ahead and, what would you say, kind of from what you've heard and from talking with the city, what would you say is the historical case for the monument?
Sure. Well, the test used to be, for 50 years, it was a test called the Lemon Test. And it was kind of a convoluted test, had a lot of different parts to it. But we were able to get that test changed at the U.S. Supreme Court in a couple of different cases of wins that we had, including our Coach Kennedy win when he wanted to pray on the 50-yard line. And so now it's a history and tradition test. And the question is, what's the history and tradition of displaying a 10 Commandments monument for a government? So where you have it at the U.S. Supreme Court, there's 10 Commandments monuments all over the country in front of various state capitals, including the Texas Capitol, in front of other cities like in Dallas and other places. And so for the city of Amarillo to be able to have a 10 Commandments monument, you're basically asking, is there a history and tradition of cities and government entities displaying the 10 Commandments all across the country and throughout time? And the answer to that is a resounding yes.
Whenever I spoke to Mayor Cole Stanley about this, he had kind of quoted me around 11 other monuments in Texas counties that have been put up in various other dates. Unlike the Austin monument, which, there was the Supreme Court ruling on, have those other displays been deemed constitutional, or have they just not seen a challenge, kind of like the Austin monument did? Yeah,
you're really not going to see very many 10 Commandments challenges anymore because of the way the law is now, with the Lemon Test being dead and it being the history and tradition test. There's just really no legal basis anymore to challenge 10 Commandments monuments. That was even probably the case before our win at the Supreme Court a couple of years ago in the Coach Kennedy case that actually destroyed the Lemon Test. Because prior to that even, we represented other cities like Sandpoint, Idaho, and some other places who had 10 Commandments monuments. and there were never any legal challenges. Almost all the legal challenges to Ten Commandments monuments have failed since 2004. Whether that would be one of the cases that came out of Nebraska, there was a case up in the state of Washington. There's been some other legal skirmishes, but most of the Ten Commandments litigation has died down because the laws changed and favors Ten Commandments monuments so heavily.
Where could you point me to where the law has changed to kind of favor the Ten Commandments monuments? And that I know you said they moved away from the lemon and they've moved that history and tradition.
Sure, there's a couple of U.S. Supreme Court cases that were actually our cases at First Liberty, and we won them. The first is the American Legion versus American Humanist Association. That was a 40-foot cross. That was a World War I Veterans Memorial, and the Supreme Court upheld that as constitutional and really put the lemon test in serious jeopardy. And then in the Coach Kennedy case, Kennedy versus Bremerton, that's when the Supreme Court said they're finishing off the lemon test and it's no longer going to be applicable. And that really changed the landscape for these types of cases. And frankly, it's just melting away the litigation that would surround putting up any kind of display that might have religious imagery. It's not like McCreary, because there the Supreme Court really applied lemon, and the reason why it was struck down was because of the lemon test. As to the type of monument it's going to be much more similar to what is being displayed down at the Texas Capitol. And there's really not if you look at many of the cases after Van Orden, there really hasn't been a lot of discussion about, how many other monuments or other displays you would need after that. But frankly, after the test got transformed to history and tradition, those types of other issues and other monuments are really not relevant anymore to the analysis.
And so whenever, kind of looking back at the Coach case, I guess I'm not fully seeing the parallels between a coach as his own private citizen, preying on the sidelines with players. I'm kind of help me clarify like how that will apply and how that could be applied to specifically Ten Commandments monuments and displays.
Yeah, because the test under the Establishment Clause, that's the clause that someone would potentially try to use to attack a Ten Commandments monument. The test had been the lemon test prior to the Coach Kennedy case, and the Coach Kennedy case destroyed the lemon test and reaffirmed that it's now going to be the history and tradition test. And because of that, the question now is not whether or not some passerby is offended by it or whatever. Now the question is this type of practice of having a Ten Commandments monument on government property, is there a history and tradition in our nation of doing this? And there's so many different Ten Commandments monuments all over the country. There's so many references to the Ten Commandments and other religious texts all throughout Washington, D.C., from the founding era to the present, that there's really no question that a Ten Commandments monument is perfectly fine sitting on the property. It really doesn't matter what else is around it.
Would the history kind of in the case of the ruling that was decided in McCreary County be included in that?
No, because that case dealt with the application of the lemon test, which actually had nothing to do with the Ten Commandments at all. It just has to do with the factors of having somebody observe it and be offended by it, and some facts that might be about what people said as they put it up and that sort of stuff. All that, none of that stuff's relevant anymore. Gotcha. Out of the new test.
There's, I guess, kind of say there is a challenge to this monument, and the agreement for you to represent the city, at no cost. However, if that happens and the monument gets challenged and we lose, does the city end up being liable for the plaintiff's fees in that case?
That certainly can happen. When Americans United for Separation of Church and State represented the school district in our case with Coach Kennedy. They got tagged with that, but I've never really had that happen to us for the past 23 years because we've been very careful of the types of cases that we take on. But I really doubt that there's going to be any kind of legal challenge to this. There really aren't those. Like I said, those cases are melting away. I mean, goodness sakes, the Ten Commandments Monument in Sandpoint, Idaho, when we represented the city of Sandpoint, I would have thought that one of the groups would have sued over that Ten Commandments Monument, but they never came for that, even though it was probably a more favorable jurisdiction for them. And that was actually long before the Coach Kennedy case.
And so are there any legal issues that get created? And this is more just kind of a thought myself. For instance, I, as a private citizen, don't have the same luxury of being able to propose this monument and then be able to approve it going up on public property. Does there end up ever being like kind of a conflict with the council themselves being able to privately fund this and then approve it themselves?
Yeah, so the monument is it is government speech. It would be the monument owned by the city. And the Supreme Court actually said in a unanimous decision in Sumum versus Pleasant Grove that if the city has a Ten Commandments monument that they're claiming as their own, they're not required to put up a monument of anybody else that might happen to try to donate something to be displayed.
I think that's all I have for you, unless there's anything else you want to add or anything you feel I didn't really touch on.
No, I mean, I just say that, 20 years ago when we would try to defend these types of monuments and we would do those cases successfully, it was a lot more difficult. But with the changing legal standard now, it's become much more straightforward. And we're seeing the result of that is that a lot of groups might try to complain about certain things, but they really don't want to bring a case because there's just no law anymore to support legal challenges to Ten Commandments monuments like there used to be.
Again, thanks to Devin for conducting that interview. We do have the full unedited interview, as I said before, with Hiram Sasser. That is over on our website, myhighplains.com. We also can go back and look at some of the other reporting we've had on this issue. It's all there as well. So the May election, it is fast approaching, and Canyon voters will be deciding on a $14 million investment into public safety. Coming up next, we're getting a behind-the-scenes look at what improvements we could see. Canyon City Commissioners voted to schedule a $14 million public safety bond for May 3rd. If approved, that bond will go toward the police and fire department as well as City Hall. Politics Today's Maya Clark has the story.
$4.9 million for the Canyon Police Department, $8.8 million for the Canyon Fire Department, and $250,000 for Canyon City Hall. $14 million total for public safety to keep up with Canyon's growing population.
Our continued call service for fire and police department are going nowhere but up. Those increases have gone and gone and gone, and so we're trying to meet those challenges, and we're trying to continue to rise up with the community as they grow.
At the police department, the funds would be used to renovate their new building, formerly the Gold Star building.
Already moved right now, and then we will work to adjust that building and adapt it to a normal day-to-day police station.
According to Canyon officials, beginning on October 1st, 2025, the fire department will have 24-hour shifts. Part of the funds will be used to renovate the station to have proper living quarters.
Use one of the bays, convert it over to a living space so we can house firefighters for 24/7 staffing. They have living quarters. They'd also have places to store their gear, which they don't now.
If approved, the fire department will also use funds to create new facilities to help with training, improve work conditions, secure accreditation, and help insurance costs.
That would also include a burn house, which is a separate structure right next to it for training purposes. We have to have that for insurance purposes on our training.
Canyon Mayor Gary Hinders shared many of the facilities they are using were built 50 years ago, and as their population has doubled, they want to keep the public's best interest in mind.
Canyon's been right at the top for years and years, a rating of a 2. Our feedback currently is that could drop if we don't do some things to take care of this.
According to Canyon officials, if the bond is approved, it'll be in effect for 20 years with projects expected to be finished up by 2030. The estimated tax increase for a home valued at $100,000 will cost them about $8 extra a month. We'll wrap things up after a quick break. Don't go anywhere. One other story we'd like to highlight this week before we go, Dr. Jamil Connor has officially started as the new Amarillo College president. Thanks for joining us.